Hello and welcome back to Learning Legislation with Cesar Lopez, Associate General Counsel of Texas Hospital Association. My name is Susanna Ramshaw and I oversee trustee programs and engagement with Texas Healthcare Trustees. If you've been following along at home, you know that Cesar provides monthly updates to THT members around what's happening at the Texas State Capitol during our 87th State Legislature. So without further ado, I will hand it over to Cesar for the update from about mid-March to mid-April 2021. Thanks for joining us, Cesar.
Yeah, happy to be here. Thanks, Susanna. Always great to be here. This is, I think, is our third month doing this. It's hopefully been it's been great on my end. Hopefully, great for everybody watching, and hopefully everyone's learning a little bit about legislation through all of these. If you've watched in prior months, again, I warned you guys I was going to be repeating this slide every single month. But again, I just want to remind you all that we do have a really helpful, really useful app out there that everyone is able to go and download onto their phone. We're loading everything we can possibly think of onto this app. Everything we can possibly put on this app is on there, whether it's recorded testimony, white papers, basic info, ways to contact legislators. All of that information is on this app. If you want to sort of follow along at home, please, I again urge you guys to go and find it, download it, use it. If there's something on there that you want to discuss in further detail or something that's not on there that you want to ask about, again, you feel free to reach out to either one of us. We're happy to have that discussion. If we can't help you with that question, we can certainly find somebody here within THA or THT that can help. So again, please, I just want to make sure you guys are engaged. I want to make sure you guys are getting the information you need out of all of, whether it's these presentations, the app, whatever it is, our webpage. Just please, your feedback is important. It really helps guide us on what we're doing. And again, I just want to make sure that you guys are fully engaged on all of these issues. So as Susanna mentioned, we're in the first full week of April now. Today's April 9th. We're really in the heart of session. It's been, I can tell you guys from our perspective, from the advocacy and legal perspective here at THA, it's been a really grueling last couple of weeks. If you watched our last update in March, I mentioned that we had expected the winter storm and COVID and all that to kind of slow things down at the Capitol. That didn't really happen. It's been, I'll tell you guys, so far, Tuesdays and Wednesdays have been heavy days for us as far as being at the Capitol, testifying, showing up to hearings, meeting with legislators. All that happens 5 days a week, during the work week. But particularly on Tuesdays and Wednesdays, we've been there really, really, really late. I think the earliest I've gone home on the last few Tuesdays and Wednesdays is probably 8:30 p.m. I'm usually here by about 6:30, so I can get to the Capitol before hearings start at 8. I've gone as late as midnight. Our GC, as I point out here in our third bullet point here, testified one of those early weeks at 4 in the morning. It was a hearing that went until 4 in the morning. Again, they usually start at 8 or 9 in the morning. So there's a lot going on at the Capitol. It's, as you can imagine, not just healthcare issues. There's bills out there. I'm sure you guys have heard about them, dealing with access to voting, voters' rights. There's always this sort of standard sort of hot button issues out there. Abortion, medicinal marijuana, things like that. As I mentioned in our first update, the budget is still kind of working in the background during all of this. So again, all to say, there's a lot going on. We're really working through these issues in real time, which can be very difficult because you might be an expert on a certain issue, might be an expert in a certain part of statute or a certain part of law, but when you're put in a room and you're asked to come up with a compromise or a workaround or a fix in 30 minutes or 60 minutes or 90 minutes, or maybe even by tomorrow morning, that's usually never enough time to really get all these things right. So that you don't know what kind of loose ends are going to be out there, what kind of downstream implications these discussions and those edits are going to have. But again, this is what we do. This is what we gear up for every other year. We all kind of love it and hate it at the same time. And again, just know that we're out here working for you all. And again, if you have anything that pops up on your end that you want to know more about, please let us know. Again, as I mentioned in the prior slide, we do have the app out there. We do have our webpage that archives all of our testimony. If we have transcripts and things like that, we'll put them up there as well. So if you want to actually go and watch videos, there's a screenshot of one of my more recent attempts at testifying on screen now. But you can just go to our webpage. It has a link to the YouTube video. You can just click that, again, if it's a topic that you're interested in or a bill that you're interested in, all that testimony will be out there. And again, if you need more than that, please let us know and we'll get that to you. So again, trying to keep these things within our 15-minute time frame, I thought I'd jump after all of that right into this month's bills of note, excuse me. Some of these bills, certainly some of these issues we've discussed on prior updates. And so hopefully they'll sound familiar to you. And as I referenced back in January, February, we start with this big bundle of bills that we're paying attention to. I mean, literally hundreds of bills that we're monitoring and paying attention to, but not all of those bills actually do anything. Some bills get a hearing, some bills don't. Some bills might get a hearing and then kind of just die on the vine, so to speak. So as we figure out which bills are actually going to start moving and that we need to care about, our focus starts to sort of shrink and shrink and shrink and shrink, to the point that by the end of session, those hundreds of bills that we're concerned about has shrunk to about 75 to 100 bills that we really needed to work on, really needed to pay attention to, and probably about 50 of those that we were probably hands-on dealing with, actually trying to modify, improve, or kill, or whatever it may be. So again, same issues as we've already talked about in prior updates. I'll try to give you more bill numbers as we work through session, so I can kind of get you more pinpointed on these particular issues. But again, starting with liability, that first bill, I know we've talked about HB 1617 and its companion bill, SB 207. So the companion bills, like I mentioned on our first update, you start either in the House or the Senate, and oftentimes folks will file companion bills. So the identical bill on both sides of the Capitol, one in the House, one in the Senate. And so you try to see which one makes it to the finish line first. But that way you have two parallel bills working in tandem to try to give folks the best opportunity to get that issue taken care of, get that bill passed. So the paid or incurred bill, 1617 or 207, we had hearings on over the past couple of weeks. Those were one of those, both of those nights actually were long nights because there were a lot of folks out there arguing and testifying against this bill, particularly providers. So there was a lot of doctors, chiropractors, folks showing up in their white coats at the Senate and in the House, basically saying that this bill is a bad idea. It will harm us from a reimbursement perspective. Within those 2 weeks, THA went from being against the bill to being neutral on the bill because we started to work on a potential solution to this issue, at least from a hospital's perspective. And again, I know we only have a couple minutes here, but basically it would be a situation where hospitals would agree to submit an affidavit for no more than 50% of their charge master rate for any given service. In exchange for that 50% rate, if you will, the hospital wouldn't really be subjected to any sort of discovery in these personal injury cases. So again, remember, these are just dealing with personal injury cases. These are the folks who get injured in automobile accidents, are brought to the hospital, checked up, worked up, sent home. They go hire a plaintiff's attorney. They go to their primary care physician, specialists, chiropractors, all of that. And then they turn around and sue the party that caused the accident for all those medical expenses. So the folks that filed this bill were taking issue with the amount of medical expenses that were being claimed in these cases. And so again, our workaround or potential workaround, we're not quite to the finish line yet, but potential workaround would be we will, for hospitals, agree to a certain cap on those expenses in exchange for keeping us out of discovery, not forcing hospitals to be deposed or turn over documents or all that sort of stuff. So again, we're in the midst of those discussions, quite literally in the midst of those discussions. I had calls before I jumped on this Zoom presentation, and I'll have calls afterwards. So hopefully more to come in the coming months on that. The second bill, HB 396, workers' comp, again, a bill I think we've already talked about during these updates. This is a bill that would flip the workers' comp presumption for nurses specifically that contracted COVID. The presumption currently is that a nurse, or any provider really, but specifically nurses, when they claim COVID, that they contracted COVID, they have to show beyond a reasonable doubt that they contracted COVID at work. We all know that's very hard to do. Folks are out in the community. There's a ton of community spread with COVID. So we are against this bill because we believe that presumption, flipping that presumption, will go too far, and it would cover folks that really probably didn't contract COVID at work. So again, another one I want you guys to keep an eye on. SB 6 is a big liability bill. Again, I think it's one that we've already discussed in these updates. This would provide pretty broad liability protection for all healthcare facilities and providers with respect to COVID. Essentially, if somebody were to file a lawsuit for care that they received during the pandemic, the hospital could come back and claim that the reason that maybe that standard of care wasn't met, or whatever went wrong, was due to COVID. Whether that patient came in at the early stages of COVID when we really didn't know what the standard of care was. We really don't know what it is yet, even now, but we really didn't know what it was back in March and April. Or a patient came in for something unrelated to COVID, but their care was affected because the hospital was focusing on COVID patients and was not able to sort of provide the normal care because they were so busy with COVID patients. So a really good bill. It actually passed through the Senate yesterday, so now it's on the way to the House. It's moving along actually quite nicely, surprisingly, to some extent. Hopefully that bill does make it to the finish line, because again, I think it provides a lot of really good liability protection for all of our hospitals and all of our providers. End of life bills, I'll try to go through these quickly. Again, this is an issue that I personally work on quite extensively. I have, I would hope, some level of expertise on. Again, some of these bills we've already talked about. SB 917, we had that hearing on Tuesday. Really bad bill from our perspective. This would require hospitals to continue providing life-sustaining treatment to an individual for about 4.5 times longer than we normally do, than we currently are required to do. The idea is that from a hospital perspective, many times those interventions don't benefit the patient, actually cause harm and suffering to the patient, or the patient's already probably medically or legally deceased. So an outright mandate to require us to keep that patient on a ventilator, on a machine of some sort, for 45 days, where you wouldn't normally do that under normal medical appropriate standards, would be problematic. Our solution to that issue is SB 1944, which is sort of a broad reformation of the Advanced Directives Act. And so again, we're pushing that bill. We're hoping that bill will gain some traction and try to resolve some of these issues. Again, if you guys want more info on that, let me know. HB 3063 deals with guardianships. There was a case out of Austin over the summer where a spouse claimed that her husband was denied care because the judge appointed a guardian and the guardian wouldn't listen to what the wife wanted. This bill would essentially require a guardian, when it comes to end of life and critical care issues, require the guardian to basically concur with the next of kin. We have issues with that bill. We did testify on that bill. We're not supporting that bill. But again, just want to let you guys know that is out there. Probably the scariest bill from my perspective on these issues is HB 4329, which would go in and just basically, in essence, undo the current determination of death. So it would make it very difficult. It would add a number of steps for a hospital or a provider, rather the provider, not the hospital, but the providers, to declare that an individual was deceased. You'd have to get a second opinion. The family could go obtain another second opinion from outside the facility, things like that. That would make it very problematic in relation to what we currently do. The dialysis bills, again, I mentioned this after the winter storm. This is an issue that popped up. There's two bills out there that kind of do the same thing. I just wanted to highlight both of them, SB 1396 and HB 3965. Pretty similar if you pull those and read them. They basically require the dialysis centers to develop either plans or alternate care strategies, enter into transfer agreements with folks within 100 miles. Basically, if you guys lose power, if there's another issue where you aren't able to service your patients, what is your backup plan? Do you have a generator? Do you have food and water? Do you have transportation to take these folks down to the hospital? Have you worked these issues out? So basically work them out on the front end before the next disaster hits. Visitation, there's a number of visitation bills out there, some dealing specifically with children, some dealing specifically with clergy. All of them sort of aimed at making sure that hospitals and nursing homes can't prevent patients from receiving visitors. The bill that we are working on and we think is a probably solution to all of these issues is HB 2211. In short, it would require hospitals, even during a pandemic or an emergency or disaster, to allow at least one visitor per patient. Subject to some exceptions. If the feds say, hey, you can't do this, we're going to pass a rule. CMS says you can't allow visitors. or if there's an infectious agent within the hospital that the hospital wants to make sure doesn't get out, the hospital can kind of close the doors and limit that visitation to 0 for a limited period of time. So again, no, there's a lot of visitation bills out there. This is the one that we're really working on. So if one moves, we're hoping it's HB 2211. Interstate medical licensure compact. This is an issue that we have dealt with for sessions and sessions and sessions. It's filed every year. We think actually this time it might actually have a chance of moving, but HB 1616 would basically bring Texas into that medical compact. So for those of you that aren't aware what the compact is, there's a bunch of states, basically all of the West Coast, the northern states, all the way over to New York, that have signed this compact. It's basically a contract and agreement between the states to allow their medical providers to work across state lines much easier than they currently do. Texas, again, is not a member of that compact, has not signed on to that compact. So if somebody wants to work in Texas, they have to be licensed in Texas and go through the normal process to receive their licensure, physician licensure in the state of Texas, as opposed to going to a state like Washington or California or New York, where they'll say, if you're a part of this compact and you're sort of coming from one of the states within that umbrella, it's a much easier process. So if you're trying to go from California to Washington, both those states are in the compact. California medical license has some recognition in, let's say, Washington State or New York State. So that physician wouldn't have to jump through all the normal hoops to receive licensure in that second state because they're coming from a compact state. So it's easier to work across state lines. It also helps a ton with regards to telemedicine, which is why I think this bill actually has a chance of moving this session, because it would also allow those physicians to work via telemedicine from another state. So right now, if a patient is physically within the state of Texas, within the borders of the state of Texas, and is receiving care while they are physically within the borders of the state of Texas, whether it's in person or via telemedicine, because that patient is located in the state of Texas, the state of Texas has jurisdiction over that patient. Because the state of Texas has jurisdiction over that patient, that physician who's treating that patient needs to be licensed by the state of Texas, again, because we're not part of this compact. So a doctor in New York could be treating a patient that's located in Texas via telemedicine, so long as that doctor in New York has a Texas license and is able to provide those services pursuant to the state of Texas's rules. If we were part of this compact, it would be a lot easier to do that. So a doctor in California or Florida or whatever, another compact state, probably wouldn't have to jump through all those hoops to be able to treat that patient that's located in Texas, again, whether it's in person or via telemedicine. Hopefully that wasn't too much of an explanation, but that's basically the idea behind that. It just makes it easier for doctors to move around from state to state without having to jump through a bunch of hoops. Two quick bills. I know we're probably already over a 15-minute time, but Prudent Layperson and Emergency Services, HB 2241 and SB 1037, again, companion bills coming over from both sides of the House, but essentially do the same thing. This is an issue that we have been dealing with for quite some time. Again, we have a ton of information out there on it. I posted a bit of our white paper here on the slide. Again, if you guys want a copy of that, let us know. We'll get it to you. But this is an issue dealing with reimbursement for ER care. In a nutshell, what happens is when that care is reviewed for reimbursement purposes, they apply this prudent layperson standard. And the question that is asked is, would a prudent layperson believe that at the time they arrived to the ER, believe that they really did actually need emergency care, that their situation was such that they thought they were having a heart attack, they thought they were having a stroke, they weren't just coming in because they had a cold or a cough or something like that wouldn't really be considered emergency treatment. They arrived to the ER for emergency care because they actually thought they were having an emergency at the time. What's happened over the last couple of years is that prudent layperson definition has been kind of muddied, and to the point where the health plans, when they review that care, look at the final diagnosis as opposed to the patient's condition upon arrival. So patient could have come in thinking they were having a heart attack, but it turned out to be indigestion or something like that. And so they say, well, it was indigestion, so the patient should have known that. We're not going to cover these emergency services. So this would basically strengthen that prudent layperson standard, strengthen that definition, to consider not the final diagnosis, but what the patient was complaining of. What was the patient actually suffering from at the time they arrived at the ER? And is that what made them believe that they needed emergency services, not their final diagnosis? Again, there's a lot more to that. Let us know if you need more information. Last bill here, I'm just kind of throwing this out there. This is not really a major issue for you all, I don't think, but the HB 1843 would allow hospitals and other facilities that are kind of under the umbrella for these infant safety issues, would allow hospitals to build these infant deposit boxes. That's probably a crude term, and I apologize, it's probably a formal term for that. But basically, these hospitals are already designated as centers where a parent can bring their child if they're unable to care for that child. If they want to make sure that their child goes to a safe place, they can bring that child to the hospital. The hospital is already charged under current law with taking that child, caring for that child, connecting that child with child placement services. But this bill, HB 1843, would allow hospitals to build and install on the outside wall of their hospital these infant safety devices where somebody would basically come in anonymously, put the child in the device, leave the child there for the hospital to take and kind of go through that process instead of having that individual come through the front door. You would basically, again, just be able to do that anonymously. Again, I'm sure there are some hospitals out there that already have these devices in place. I don't know how widespread that use is, but again, if you're one of those facilities that already has gone through this process with the intake of those infants, taking those children, connecting them with child protective services, child placement services rather, this may be a bill that you might want to pay attention to. Again, probably not a huge issue, but just something to know that that it's out there. And again, any questions on any of these, we're happy to have that discussion. Whatever information we can share with you all. So Susanna, again, I think we went over a 15-minute mark, but
no worries. You're
yeah.
such a wealth of information, and your summaries are really, really helpful, especially for somebody like me who, I'm not there in the day-to-day and in the weeds. Can you go back one slide and just this document that you have here, this screenshot, is that a one sheet that you have on the website that folks can download?
So we have a bunch of one pagers. I mean, we have one pagers for all of these major issues that are out there. I think we have one for dialysis. We have one for end of life, certainly, and liability. Again, there is a lot of information out there. If this is something that you at home want more information, kind of quick bites, we have these out there. Let us know. They're on our webpage. You can find them. If you can't, email Susanna or myself. We'll get it to you. These are things that you can distribute within your facility, educate your folks on, get conversational on these topics if you wish. So again, they're out there. They're out there for your use, for your benefit, and please make sure that you, when you need something, you go out and pull it and use it.
Great. Thank you. Yeah. Well, we really appreciate your time. I know you've had a lot of long days and late nights. And so, making the time and space for us and for this audience is really appreciated.
Yeah, happy to do it. Always happy to do it. I look forward to these every month. I'll tell you. Yes.
Well, we'll see you next month, which may be the last month of session, but probably not, right?
Yeah, we'll probably have to do, I think we'll have one in May, and then we can do a wrap up in June. So probably at least 2 more.
Unless we have special sessions.
Unless we have special, right? Which probably we're hearing will be in the fall. So we hopefully will have the summer off. But again, who knows?
Well, sounds good. Well, we'll see you next month. Thank you so much.
Right. Thanks, everyone.